Welcome back to Trial by Podcast. I'm Jemillah and I'm here today with my colleague Chelsea to discuss the highly anticipated workers' compensation reforms, particularly the reforms focusing on psychological claims and claims involving workplace harassment and bullying.
Yes, and thank you for the introduction, Jemillah. After many months of parliamentary inquiry and debates, we finally have the Workers' Compensation Legislation Amendment Act 2025 and the Workers' Compensation Legislation Amendment Reform and Modernisation Act of 2026, which together set out the biggest overhaul of the workers' compensation scheme since 2012.
That's right, Chelsea. This reform process began in early 2025 in response to growing issues and increasing pressure within the state workers' compensation scheme, particularly in relation to psychological injury claims. Some of the major pain points for the scheme was rapidly escalating costs, declining return to work outcomes, and serious concerns around employees increasing premiums.
Yeah, it was really starting to weigh on the system. And in response, the New South Wales Treasurer, Daniel Mookie, delivered a ministerial statement on the 18th of March 2025 announcing major reforms to the New South Wales Workers' Compensation Scheme, largely targeting the surgeon and management of psychological claims. Following this announcement was the release of the Workers' Compensation Legislation Amendment Bill in May 2025 and the subsequent Workers' Compensation Legislation Amendment Reform and Modernisation Bill in August 2025.
Now, the first bill sets out the key policy changes, particularly reshaping psychological injuries are defined, the threshold for psychological claims, changing the limits to long-term entitlements, and changing how disputes are resolved, and particularly those involving workplace harassment and bullying. It also set a new policy direction focused on sustainability, prevention, and supporting recovery through work.
Yeah, and then the second bill was introduced to build on these improvements by providing more clarity on the mechanisms of implementation, such as setting out the commencement dates, the transitional arrangements, and the long-term structural setting of the new scheme. But it also incorporated the amendments from the discussions and debates on the first bill. But what did Parliament say about these bills?
Yeah, as Sophie Costas, Minister for Industrial Relations and Minister for Work, Health and Safety, explained in her second reading speech of the bills, the reforms are aimed to modernise the system so it delivers better outcomes for injured workers, while remaining fair, efficient and financially sustainable for the future. The changes allow the scheme to be better catered towards serious workplace injuries by introducing clearer definition, tests for objective decision-making, and new pathways to resolve claims.
Okay, well now, Jemillah, we won't be able to cover every amendment in these reforms today. Otherwise, we'll be here for hours. So instead, we're going to be focusing on one of the biggest changes, which is the new process for dealing with claims that involve workplace disputes and the involvement of the Industrial Relations Commission. But first, I think we should take a step back and cover the process that brought us here and why these changes have been introduced.
I think that's an excellent idea, Chelsea. As we already stated, the reforms are focused on introducing a new, modernised legislative framework to deal with psychological injuries in New South Wales workers' compensation claims, as well as aiming to enhance efficiency, streamline processes, and strengthen the integrity of the workers' compensation scheme across the state.
Exactly. And the reforms are also part of a larger New South Wales government initiative roadmap to align workers' compensation, industrial relation, and work health and safety laws into a more coherent end-to-end system with the overarching goals of prevention, early intervention, faster decision-making, and better return-to-work outcomes. Research done in the preparation for these reforms revealed that there had been a growing trend in recent years of psychological workers' compensation claims involving issues that went beyond just personal injury matters, such as interpersonal conflicts, performance management disputes, excessive work expectations, and allegations of workplace bullying and harassment.
And that's where the Industrial Relations Commission is proposed to come into play, Chelsea. In developing these reforms, it was recognised that the Industrial Relations Commission, being a more specialist workplace tribunal, is better placed with their expertise to make determinations in disputes involving allegations of these kind of conduct. A specialist workplace tribunal, the RSC is uniquely placed to assess whether conduct crosses the line into bullying or whether it falls within reasonable management action. Those are assessments that RSC make every day, applying established industrial principles to real workplace contexts.
And that's definitely a logical approach to take. It was made clear during the parliamentary debate that psychological injuries, particularly those arising from workplace behaviour, have not been well served by the current system focused on primarily medical evidence and compensation thresholds. Research and consultations highlighted that these disputes were often prolonged, adversarial, and slow to resolve, with poor return to work outcomes for the injured workers.
It was therefore proposed by Parliament that the Industrial Relations Commission, with the involvement of their qualified experts, is a more appropriately placed tribunal to make findings on these matters to ensure the consistent application of industrial relations principles. The idea is to resolve disputes about behaviour and expectations before they escalate into these entrenched psychological injuries or long-running compensation injuries.
Yes, and as we previously stated, this also aligns with the New South Wales Government's broader anti-bullying policy framework. The New South Wales Government has openly acknowledged the serious harm that workplace bullying can cause, not only to the individuals, but also to their employers and their broader economy. Strengthening anti-bullying jurisdictions, particularly for workers who previously fell through the jurisdictional gaps, reinforces the commitment to a psychologically safer workplace.
Ultimately, the involvement of the Industrial Relations Commission would be about using expertise where it is most effective. Parliament's intent was clear. Workplace conduct issues belong in a forum designed to understand workplaces. That policy reflects a government's focus on prevention, fairness, and better outcomes for workers, employers, and the system as a whole.
Now, as we explained, however, the IRC is not going to be taking over these claims in their entirety. And it was still yet to be clarified how exactly the industrial relation is going to be involved, but the PIC will still be playing a very large role in these claims.
Exactly. The Personal Injury Commission will continue to have jurisdiction to examine, hear, and determine all other matters under the workers' compensation legislation, including making determinations in relation to psychological claims involving workplace disputes. And there is just a new process for these types of claims, making it to the Personal Injury Commission.
Right, because currently, if I was an injured worker that has a claim and the employer has an arguable 11A defence, I would just go straight to the Personal Injury Commission to resolve it. But what's going to happen now?
However, now the worker must identify the relevant conduct they rely upon. Otherwise, the claim is declined and the gateway to dealing with the dispute is through the Industrial Relations Commission. How about for everyone at home to better understand this process, we do a mock scenario right here in studio.
Oh, I think that's an excellent idea. Can I be the injured worker?
Absolutely, Chelsea.
Excellent. Okay, let's say I am a worker and I feel like my boss has been sending me sizable tasks quite late at night and with really unreasonable deadlines. And even when I do return the work, it's been unrelenting with criticism. It's really affecting my mental health and causing immense anxiety and feelings of depression to the point I can't show up to work. As a result, I've gone to my doctor and obtained a medical certificate saying I'm unfit for work. What do I do now?
Well, first, under the new proposed reforms, parties need to identify if the psychological injury involves on what the legislation now calls relevant conduct.
Right. And what does the legislation call relevant conduct?
Great question, Chelsea. Relevant conduct is defined by Section 280AB, which arises from bullying, excessive work demands, racial harassment, and sexual harassment. When a psychological injury arises from one of these events, it is then defined as a relevant injury.
Okay, well, it definitely looks like my situation falls within this definition. So how does the new proposed pathway affect how my claim will be run?
The insurer will still have to determine your claim. And under the new Section 280AC, the insurer has 42 days to determine liability, which is a strict deadline. It will be very interesting to see how insurers and employers gather crucial information such as a statement evidence in a relatively short period of time.
Yes, because that definitely is quite a tight deadline for such a complex issue. But what happens if the 42 days passes and I haven't heard anything?
This is one of the most significant practical changes for insurers and employers. It appears, based on how the legislation is currently written, that the 42 timeframe is strict. Per Section 280AC, the insurer must decide to accept the claim or dispute the claim. On liability, if an insurer does not issue a Section 78 notice within 42 days of receiving a relevant injury claim, liability is deemed to be accepted. Once that timeframe passes without a notice being issued, the insurer is required to accept the claim and pay entitlements. So that would mean basically happy days for you, Chelsea.
Okay, so under the proposed scheme, I definitely have a clearer timeline for decisions. But as an injured worker, what do I do during the 42 days? What entitlements can I receive?
This is, again, another massive positive for you, Chelsea, as a worker. During the 42 days, the insurer is to pay weekly benefits and medical expenses as per 280 AD.
Okay, so I received my determination and the insurer is disputing my claim on the grounds my claim is not in relation to irrelevant conduct. What do I do now?
If you disagree with the insurer's decision, you must first request a review of that decision before the dispute can go to the Personal Injury Commission or, as we discussed, the Industrial Relations Commission.
Okay, and how long do I have to wait for this review to pass?
Under Section 280 AE5, once that review is requested, the insurer must complete it and notify you as the worker of the outcome within 14 days.
Okay, so I've done my review, I've got the determination back again, and the insurer is still maintaining their denial of the claims on the grounds as not relevant conduct. Where do I go now?
Now, this is kind of where it's going to get a bit real, Chelsea, so buckle in. So under the proposed new pathway, if the insurer disputes liability on a specific basis, saying under Section 280 AH1 that the conduct you're alleging is not relevant conduct for the purposes of this pathway, then you, as a worker, have to make an application to the Industrial Relations Commission.
Okay, so this is where the IRC comes in. So unlike in the past where if my insurer was denying my claim, I would go straight to the Personal Injury Commission to make a determination. I'm now required to go to the IRC for a determination about whether the conduct was or was not relevant conduct?
Yes, and the RSC also considers evidence the employer may have regarding reasonable management action.
Right, okay. So practically speaking, this means unlike what we used to do, I can't go straight to the PIC. I need to go to the IRC for a determination on relevant conduct. But what is the effect of the IRC's findings?
From there are really two forks in the road. First, if the RSC finds that the conduct is not within the meaning of Division Section 280I applies, the RSC makes a determination that there is no claim or compensation payable. However, if the RSC finds the conduct is within the meaning of the division, then the RSC provides a certificate of determination to this effect. And under Section 280IA2, the worker must give the insurer a copy of the certificate of determination, and then the insurer must issue a decision notice about the claim.
Okay, so now we're essentially back at the start of the current system where I put my claim to the insurer and they make a determination on the claim as a whole.
Yes, how did you know, Chelsea? Too smart. It is now open to the insurer to make a determination in relation to the claim, and if the insurer decides to continue to dispute your claim, you can make an application with the PIC, which means you can then follow the existing claim process.
Okay, I see this now. I understand the new process. But when do we expect this new process to be coming into effect?
The proposed commencement is 1 July 2026. However, in the meantime, we are going to be keeping close eye on the developments and keep you updated if anything else arises.
Okay, that would be great. Please do. Because we did also briefly touch on the Section 11A and the predominant injury test. But what about the reforms to those provisions?
Oh yes, the new reforms have changed the meaning of this provision. However, that will need to be covered in our next podcast because bit much for today.
I think you are right. We've definitely covered a lot of information today. This discussion has been really insightful and cleared up a lot of my questions about the new Workers Compensation Scheme. I hope you can all join us in our next podcast when we discuss the Section 11A changes and, spoiler alert, the significant cause test and the changes to psychological injury thresholds. Thank you, Jemillah.
No worries, Chelsea. Thank you.